Chapter for the wonderful initiative of having a conference every year on such an important theme. And I'll begin by acknowledging the traditional custodians of the land on which we live, the Wurundjeri people of the Kulin Nation, pay my respects to elders past, present, and emerging. And I think the emerging side of our acknowledgements is all the more important, particularly in the context of the topic that I'm speaking about, which is the project I launched at our Human Rights Awards lunch in December last year, Free and Equal, an Australian Conversation on Human Rights. The title is one that would be familiar to any of you, and we were reminded of it by getting the Universal Declaration on Human Rights in our conference packs, because the title comes from the first article of the Universal Declaration, that all human beings are born free and equal in dignity and rights. And that's the bit that we were capturing in the title. Why did I want to launch a conversation of that kind with a title of that kind? I wanted to lift the discussion, and I visualised a sky anchor. And I threw my sky anchor into the air, framing a conversation that I wanted to lift the way that we were thinking. We heard some observations in the previous session about things getting political. Well, that's exactly what I had in mind. I wanted to get above politics, and ahead of it in some respects, but certainly above politics. And so channeling the idea of the Universal Declaration on its 70th anniversary last year through its major commitment in its very first article is how we wanted to stick that anchor very firmly in the sky. And we did it by asking a big question. We asked, what kind of Australia do we want to live in? Not just for ourselves, but for our children's children. What makes an effective system of human rights protection in 21st century Australia? In launching that big idea, launching my sky anchor, I explained why I thought we needed a project of such a kind now. Because we seem to have lost sight of the overall purpose of protecting the human rights of the whole community. Our legislation is not comprehensive in its protection. Our discrimination law is complex and does not protect everyone in our community. And while our discrimination laws are important, as they directly reflect our international commitments and can achieve many positive systemic outcomes, but they're framed in the negative of what you can't do, and rely on a dispute before offering a solution. When our human rights system was introduced in the 1980s, in the wake of Australia's ratification of the International Covenant on Civil and Political Rights, it was innovative, but has now been surpassed well and truly by developments in other countries. And so I thought we need to reimagine our system of protections on human rights and freedoms so that we can provide everyone with the opportunity to be the best that they can be. It's about people, as our speakers in the last session reminded us. And coming into this role 2 years ago next week, I brought with it a certain dismay about how human rights debates had been characterised over the past decade. I saw that they were divisive and that they pitted people against each other. The debates have been myopic and they've been focused on what I've described as individual spotfire issues, without considering the broader landscape in which they occur. Issues have been resolved, if I can put that in inverted commas, with stalemates, people being divided about what reforms are necessary, and limited change actually occurring. There's been a clear movement away from consensus approaches to human rights where there is a commonly agreed and commonly expressed commitment to key human rights priorities for the nation. Quite unlike the context in which the Universal Declaration of Human Rights was developed through a considerable consensus of very opposing conceptual and philosophical backgrounds into the marvellous document that we have today. And thinking of that, the commitments that that Universal Declaration had in mind, and looking at the path of how we've responded to even signing up to treaties, I found it most instructive to get out a red and a blue pen, red for Labour, blue for coalition. And I went down the list of all of the conventions that we've signed and their ratifications. And blow me down if you don't get an equal split. There are as many blue as red. That is not a political commitment. That is a commitment by governments of both persuasions over the past 40 plus years. Over nearly half a century, our human rights commitments, at least as they are expressed at that level, have been above the politics of the day. It's not a Labour nor a coalition project. The problem, though, is when the pattern of human rights is framed around a language of dispute, has meant that each time a new controversy arises, freedom of religion being the most recent example, people are so entrenched in their views that the broader conversation we need to have is not the one we actually end up having. Assumptions are made and labels used to characterise opponents, none of which I think is helpful. What concerns me about this is that human rights are not being properly considered, and the outcomes we all think are actually important are lost sight of. After all, human rights are not absolute, immutable propositions. There are only a few that are. There are checks and balances that exist with all human rights. There are strict criteria for when you can limit rights, and some circumstances where any form of limitation is not acceptable, like the right to life, freedom from torture, freedom from slavery. And where there is a conflict of rights, there is clear guidance in our human rights framing as to how you balance rights. So human rights law properly applied provides a set of tools to guide decision-making by making transparently known the various factors that are being weighed up. There is a way through. They shouldn't be perceived as necessarily in conflict, but an engagement on their resolution. In conducting my Skyhook project, Skyhook project, we're looking at ways to fully integrate human rights into our national systems of law, policy and programs, so that human rights become a deliberative tool to aid better government decisions and not just chucked in as an afterthought. To achieve this, to create the gravitational pull that my Sky Anchor, I hope, will provide, we are embarking on an ambitious program of work over the next year. In April, we released an issues paper to open up the process, to provide a basis of listening to people's reflections on what rights mean and matter to them, and what they think government should do about both. Human rights lawyers would be familiar with the framework that we've deployed in the issues paper, the Respect, Protect, Fulfil framework. It's a way of showing the various obligations on government, if they are to fully protect human rights or remedy a breach of them. And it is a way of navigating through or beyond the proposition that there might be one measure or a silver bullet. There isn't. It is a much more sophisticated and nuanced endeavour that requires multiple actions across multiple areas, with deliberative mechanisms in place. Let's unpack this a little. Start with respect. The obligation to respect human rights in general terms is for the government to ensure that in its own actions it does not breach human rights. What should they do to achieve this? Some examples that we provide in the issues paper, things like this. That human rights are protected in Australian law and remedies are provided for breaches when they occur. This is what respect means. That mechanisms exist to enable the participation of affected groups in law and policy making. We heard a bit about that again in the previous session. Examples, an Indigenous voice to Parliament fits in that category, as does the principle of free informed consent, so important in the world of disability policies and actions, and in Indigenous policies, and in the context of approach to elder abuse. Another example, that gender and child's rights impact of laws and policies is understood. The obligation to protect human rights, the second piece in that framework, goes further than this. It requires action by government to prevent others from breaching rights. Some examples of this may include that there are laws that make discrimination unlawful and provide remedies for breaches. That there are business obligations to respect and protect human rights. For example, human rights due diligence to identify, prevent and account for human rights risks and impacts. The recent example is the development of modern slavery statements, is an example of that kind of action. And another protective action is through human rights education initiatives that build awareness of rights and responsibilities in the community, and the understandings are woven into school curricula. And then the third pillar, the obligation to fulfil human rights, requires positive, proactive steps to fully realise human rights and address inequality. Some examples of actions that this may involve include targeted programs to address known inequalities, like the Close the Gap campaign, national frameworks on family violence, child protection, and the National Disability Insurance Scheme. It also includes proactive planning and measurement frameworks to address priority human rights issues. For example, a national action plan on human rights, national implementation mechanisms for the Sustainable Development Goals. So, through the national conversation, we're seeking to locate the discussion and debate within an understanding of that three-part framework, to have people think about the measures across all of these domains that are needed if we are to truly realise and fully protect human rights, to embed human rights in our national psyche. By the middle of next year, what we intend as the National Human Rights Institution to do is to recommend an agenda for federal law reform to protect human rights and freedoms fully, to recommend priorities for reforming federal discrimination law to make it more effective, comprehensive and fairer in its protection, and simpler to understand, to articulate key actions that all governments must take to adequately protect the human rights and freedoms of all Australians, to identify how we can build community understanding and partnerships to realise human rights and freedoms, and to identify options to invest in and build community capacity to realise human rights and freedoms. It's a big agenda. We've opened up our issues paper for public discussion and look forward to hearing from people about their priorities for reform across these areas. But it's not only that issues paper that we are doing. And I want to give you advance notice of the technical papers that are coming out in certain specific issues, which will call upon particularly stakeholders who have technical knowledge and experience to help us in formulating some of the things that we wish to include in that ambitious reform agenda. So, over the next 12 weeks, what we're going to be doing in ramping up our activities, next week we will be releasing a discussion paper setting out a federal discrimination law reform agenda, again for public feedback. In mid-August, so that's about 3 or 4 weeks away, we will convene a technical workshop on national accountability mechanisms for human rights. So how do you evaluate, how do you track how you are going? And in late August, we will release a further discussion paper outlining proposed reforms to federal law and policy to positively frame human rights, moving them from reactive tools to proactive considerations. Of course, what that involves is how you frame an understanding of rights and freedoms in a positive way. I speak of the history of the Human Rights Commission as like a donut. We were designed as the implementation in Australia of the government's commitments in signing and ratifying the International Covenant on Civil and Political Rights. That happened in 1980. The first of the commissions was established in 1981 under Dame Roper Mitchell. In 1986, the commission was put on a permanent footing, and at the time there was a proposal that in conjunction with the continuation of the commission on a permanent footing, that our jurisdiction in relation to the ICCPR commitments would be domesticated through an Australian Bill of Rights Act. It wasn't the first time that had been proposed, but it was central to the design of the Australian Human Rights Commission in 1986, that it be designed with that as the centrepiece. That part of the legislation passed the House of Representatives but failed in the Senate. The rest of the architecture was built, and a jurisdiction which is still directly referable to the International Covenant on Civil and Political Rights, although no one actually sees it. But it's like a donut with that missing piece in the middle. Our laws got all the negative bit, the yang bit, but the yin bit of the positive framing is still waiting to happen. That can happen through an Australian Human Rights Act, but it can also happen in a range of other ways. So we're looking at all of the ways that we can embrace a positive approach to human rights in the embrace of legislation and other measures. So, accompanying those three pieces, discrimination law reform, technical work, the technical issue of implementation, and the positive framing of rights, we will be convening a series of technical workshops to just consider these discussion papers over the coming months, as well as the continuation of general community consultations nationally. This week I was in Brisbane on Tuesday and Townsville on Wednesday, so a beginning of a rolling program of discussion around these issues. And this week we also announced the centrepiece of our National Conversation project, which is our National Conference on Human Rights. This will be taking place in Sydney on Tuesday the 8th of October with our special guest, Dr. Michelle Bachelet, the United Nations High Commissioner for Human Rights. The date I should flag was not the first choice of date. We had the conference scheduled for Friday, but due to essentially non-negotiable commitments in the or changes in the High Commissioner's diary, it had to be moved to the Tuesday. Now I'm acutely aware that that is the eve of Yom Kippur, and I apologise if that creates problems for any people who adhere to the traditions of the most sacred date in the Jewish calendar, and we will ensure that there are arrangements for access to the material one way or another, for those who, for all kinds of reasons, religious and otherwise, may not be able to join us on that day. The High Commissioner will be exclusively the guest of the Commission for 3 days. In other words, we have full dibs, and will participate in a range of consultation activities for the national consultations, as well as the conference, and also some meetings with government. The busy period will end the following week, when we also host Professor Manfred Novak, one of the world's most eminent human rights lawyers. He has many human rights groupies in the world, so if you want to swoon, you can swoon now. We will certainly get him to autograph his treatise on the Travaux Préparatoires of the International Covenant on Civil and Political Rights. Again, you can swoon. Sorry, I'm a bit nerdy in this world. And you can also sort of see the law reformer coming out in the program that we initiated. Right, well, you don't have to swoon. But on Wednesday, the 9th of October, Professor Novak will be launching at the UN General Assembly the UN Global Study on Children Deprived of Liberty, an internationally significant moment for the protection of children's human rights. And that is a study that he has led for the UN. He will then fly directly to Sydney, and the Commission will host the Oceania launch of the global study for Professor Novak. He will then participate in further workshops looking at juvenile justice reform, immigration and asylum seeker issues, especially relating to children, and challenging issues relating to persons with a disability, including, for instance, their being housed in aged care facilities. As a leading expert on the Convention Against Torture and primary author of the OPCAT Treaty, he is well placed to assist in domestic discussions, which then can feed into the 2 Royal Commissions which are currently on foot. So to conclude, a call to action. Our system for protecting human rights is simply not good enough. We do not have a sufficient level of proficiency or fluency to converse in human rights terms when discussing issues of major concern to the community. There is a lack of common purpose about what human rights outcomes we aspire to achieve as a nation, so that we can be the best that we possibly can be. We don't have something we can put on the fridge to talk to our kids and our grandkids about over their cornflakes. Michael Kirby remembers the moment of the passage of the Universal Declaration of Human Rights because every school child in Australia was given a copy of the Universal Declaration on that wonderfully flimsy aerogram paper that some of you may recall. I think the time is right and the sensibilities of a nation are right for that kind of return to the imaginative force that propelled the United Nations to adopt that fabulous document, the Universal Declaration. And while federal policy on human rights drifts along without that clear purpose and vision that the UDHR embodies, community pressure to change this is also somewhat lacking, and this is the call to action. Everyone needs to do more if we are to fully protect human rights in Australia. It is harder to reach a destination without a map. We need to have some hard conversations to identify the priorities for action and reform, and the basis on which we balance competing interests. There is always a place in human rights discussions for competing interests. Human rights law is about the resolution of competing interests with a principal focus on the dignity of each human being, free and equal in dignity and rights. So, please join us in the national conversation. For our part, we will provide you with clearly articulated views on what we think needs to happen on the priorities for reform. We look forward to you agreeing with us or disagreeing with us about these priorities. That is the essence of a good and constructive conversation. It is respectful. Let's make this a truly Australian conversation on human rights.